Welcome back to Last Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss a case where a police officer enters a private backyard. He observes a vehicle covered with a car cover. He suspects the vehicle is stolen, so he makes a decision to take the cover off to reveal the VIN number. The question becomes whether taking a car cover off the vehicle constitutes a search under the Fourth Amendment. And before we go on, I want to thank you for watching me on YouTube and hitting that subscribe button. Also sharing my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lostdash.com and check out some of my merch. And speaking of all that merch, I'm now going to be offering membership on YouTube. So other than hitting that subscribe button, you can also now join and become a member of this channel. And for a monthly nominal fee, you will receive some of the perks, including having a special icon next to your name. So next time you post a comment, your comment will be more visible to others and to me, and I will try to always answer those first. And most importantly, you will receive 15% off on all of my merch on my website. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we'll be discussing United States versus Montes, which is a forfeiture of property, namely 2 vehicles and $270,000. Even though this is a civil forfeiture case, it is still a good example of whether taking a car cover off of a vehicle constitutes a search under the Fourth Amendment. First, let me give you some factual background. Officers receive a complaint of loud music. They go out to the scene, and when they arrive, they hear loud music coming from a pickup truck parked at one of the residencies. When they go up the driveway, they announce their presence, but nobody answers. They approach the front door of the house, which is slightly ajar. They once again announce their presence, and once again, nobody answers. So they walk into the house, which appears to be empty. They slowly make their way to the backyard, where they're greeted by the owner of the house. While one of the officers explains to the owner of the house the reason they're there, the second officer observes 2 vehicles parked in the backyard covered with opaque car covers. The only thing that's visible are the license plates, and those are Mexican license plates. The officer believed that vehicles are often stolen here in the United States and sold to Mexico. With his suspicion, he makes a decision to lift the car covers to reveal the VIN numbers. When he does so, he later reports that the VIN numbers were missing because they were not apparent or visible from the exterior of the vehicle. The officers make a decision to detain the owner of the residence and impound the 2 vehicles. They call up some backup, other officers who will impound the vehicle. An additional officer then opens the vehicle with a Slim Jim. He finds the VIN numbers, but he also finds some containers and $270,000 in cash. Now remember, this is a forfeiture case, so now the owner of these vehicles says that his Fourth Amendment rights were violated and that the search was illegal and unconstitutional. He says that he made an agreement with the owner of the house to park his vehicles in the backyard for 1 year. He gave the keys to the owner of the house, but he did not give him permission to open the vehicles or drive them. Now, remember, the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. Now, here, the question is whether this is a search, but before we answer that question, in order for you to invoke the Fourth Amendment, Mr. Montes has to show that he has a reasonable expectation of privacy in the place to be searched. Nobody questions the fact that he does not have a reasonable expectation of privacy in the residence itself or the backyard. After all, he doesn't live there. He's not the owner of the house. He's not the owner of the backyard. He simply parked his vehicles there. But he did, however, retain expectation of privacy in the vehicles themselves. After all, he gave the keys to the owner of the house, but he did not give him permission to open or drive those vehicles. So the next question becomes whether this is a search. Now, at this point, at the appellate level in the Ninth Circuit, the government does not even argue the fact that there's no probable cause to search these vehicles. And indeed, there was no probable cause, says the court. The fact that the vehicle has a Mexican license plate does not reveal the fact that it was stolen. And so the court says there's no probable cause. And then at the appellate level, the government no longer says that this is a search. And indeed, again, the court says that lifting an opaque car cover constitutes a search under the Fourth Amendment. The government says that nevertheless, the officers were justified in opening up the cover, taking it off the vehicle to simply inspect for the VIN number. So first, let's take a look at the statute that deals with VIN numbers here in the state of California. California Vehicle Code Section 10751A, concerning the VINs at issue in this case, does not require that the VIN be displayed at all times in open view, but rather the requirement is that no person shall knowingly buy, sell, offer for sale, receive, or have in possession any vehicle or component part thereof from which the manufacturer's serial or identification number has been removed, defaced, altered, or destroyed. The statute in a nutshell does not require that the VIN number be unobstructed. It only requires that it is not be defaced, altered, removed, or destroyed. So the next question is whether the police officers can be justified in taking the cover off simply to inspect for the VIN number. To create precedent where the police officer may uncover or enter a car at any time to inspect the VIN would permit the police to rove the streets, to remove car covers, or break into any automobiles where the VIN number is obstructed in some way. In this case, the removal of the car cover without probable cause was an unlawful search. Such a precedent would be equally applicable to a car that was not covered, but where the location of the VIN was obstructed in some other way. Thus, if a car owner happens to have a sun deflector on the windshield or a paper covering the VIN in his or her parked car, police would be authorized without any probable cause to break into the car merely to determine whether the VIN has been removed, defaced, altered, or destroyed. The takeaway from this case is that removal of a car cover constitutes a search under the Fourth Amendment, and evidence, which is a product of the search, shall be excluded from trial. If you enjoyed this video, please give it a thumbs up. Please subscribe to my channel and consider becoming a member so you can get that 15% off of my merch. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch. And once again, if you're a member of this channel, you will receive 15% off. Thanks for watching.